I've had a very helpful letter this morning from ACS Law, which, combined with what the ministers were saying on the last occasion we discussed this, lead me to have a greater understanding of their reluctance to deal directly with the practices that ACS Law are pursuing. And that is, I think, that they expect these practices to become standard. They expect this to be the way that our citizens will be treated, that if they fall foul of this bill as we are writing it, they will have a couple of warning letters, yes, but once they're through that, they will be into a typical ACS standard letter saying, pay us £500 or we'll take you to court. And if they do not pay the £500, they will end up in court with a terrifying lack of defence, because they will have no way. I mean, there will be technical evidence against them, and they have no ability to provide a technical defence. And that is the difficulty which people faced with ACS Law have at the moment, that there's this inequality of arms, and they are in a civil court with a 50-50 balance of probability judgment, and they are finding it extremely difficult to contemplate the thought of risking thousands of pounds in mounting a defence to something when they don't, as I say, have an easy ability to do that. It is, and I really think we should think extremely carefully before we make it allowable for the mainstream copyright owners, make it acceptable is perhaps the right word, for the mainstream copyright owners to pursue this sort of course, because we have sanctioned it in this bill and have talked it through carefully. This is not a comfortable or a pleasant procedure for people to find themselves in. And there are thousands of people who feel that they have been done in by ACS Law, are being unjustly accused, and are finding it extremely difficult to satisfy ACS Law that they are in fact innocent. These things rarely seem to come to court. But it is, my lords, nonetheless, it appears to be a process which is taking place entirely within the recognised arrangements of the law, and there is as yet no sanction or judgment against the practice from the SLA or any other organisation. So I think we must expect that this is the experience that tens of thousands of citizens are going through at the moment, and it will be hundreds of thousands or a million or more citizens once this bill is through. And it produces extreme worry and unhappiness because of the lack of ease of dealing with it. And I think we really do have to think, as this bill goes through, what is proportionate, what is reasonable, how we balance the interests of the copyright owners with our duty towards our citizens to make sure that they are not put in fear and worry over something that they find it extremely difficult to comprehend or defend, merely that they have a deep feeling that they have been wronged because they know that they themselves have not done what they are accused of. I do think the government hasn't got this balance right, and I do think we need somewhere in this bill, and these are suggestions as to how we might start to tackle it, somewhere in this bill, a real understanding that there must be a balance between copyright owners and citizens, that it is not a matter of some heinous and absolute liability, like sticking a knife into a person, that this is something which can be, A, done unawares, and secondly, can be extremely difficult to tackle in court. I beg to move.
I just wanted to make a very brief intervention on the noble Lord Lucas's amendment, because I think he's raised some very important points here. We obviously debated this at some length in the last committee day, but my lords, what I wanted to point out to the Minister was that having made various statements on the record in the last committee day, I was inundated with correspondence following that day when the impression was given that the Solicitors Regulatory Authority had not received complaints about the activities of ACS Law and, it now transpires, Davenport Lyons. My Lords, in fact, there has been a torrent of complaints to the SRA, and I've sent the Minister an email, which I hope he's received, setting out at some length the material that I've received. My Lords, this is clearly a matter of great importance, and exactly in the way that the Noble Lord has described. There are some extremely unjustified and extremely unpleasant ways of addressing the matter that are being adopted by some of these firms against perfectly, I hesitate to use the word innocent, in the sense they are people who have not breached copyright, so what that makes them I don't know, but certainly they're not been acting illegally and are certainly not guilty of any criminal offence. So, my Lords, this is a matter of some importance, and the SRA is certainly apprised of the matter. Perhaps they're not moving fast enough, but the Minister and his colleagues in the business department and indeed in the DCMS should be fully aware that this is a very hot topic, and there have been complaints of professional misconduct against these firms involved.
I would just like to say, as someone who's really quite keen that those who produce material which is then shared, as it were, without any remuneration to the originator, I'm in favour of them being properly compensated for that which is downloaded. So I speak as someone who for the first time also received a letter about ACS Law, and I do have to say that I found that pretty disturbing, and not least that AC Law have up to 6 years to keep this particular correspondent hanging around, and even though he's been in touch with the SRA again, it doesn't seem to have moved particularly fast, let's put it like that. And one's only hearing one side of the story, of course, so can't say more than that. But it certainly is worrying, and I assume the Minister is going to address this very seriously when he replies, because I gathered from the shaking of his head that he was aware himself of at least some of the complaints that have been coming in this direction.
The possibility that one of these matters might be overlooked in a hasty assessment, or indeed completely ignored in a rush to implement the necessary steps, is worrying. I hope that this amendment will do much to promote a considered approach. I also have received correspondence about these people sending out bullying letters, and I add my plea to the Noble Lord the Minister, if only to say something in Hansard. It was said in Hansard that we can send to those people that have corresponded to us, pointing out how appalling their behaviour is.
We must have something to make sure that Norwich Pharmacal orders are not given willy-nilly to people who have not gone through this procedure. We've produced some comfort for the citizen in this bill. We've at least got to make sure that judges consider whether or not this procedure should not be used before Norwich Pharmacal orders are granted. And we must do something about the quantum of damages which is being sought, because in a civil procedure on a technical matter, it amounts to blackmail, because the cost of defending one of these things is reckoned to be £10,000. You can get away with asking for £500 or £1,000 and be paid on most occasions without any effort having to be made to really establish guilt. It is straightforward legal blackmail, and we must do something about it by making sure that where damages are asked for, they are at least for first offenders at a rational level.